The ultimate results here yet to be seen, but it is victory tonight for the two couples which launched the legal battle to challenge Proposition 8, claiming that the ban had violated their civil rights. Their case argued in court by former U.S. Solicitor General Ted Olson, as well as David Boies, bringing together the two litigators best known for representing George W. Bush and Al Gore on the opposing sides of the 2000 presidential election recount. They'll be joining Rachel Maddow at the top of the hour. Meanwhile, the original defendants in the case, California Attorney General Jerry Brown and Governor Schwarzenegger, the Schwarzenegger in Perry v. Schwarzenegger, refused to support Proposition 8 in court. That left it to the group that put Prop 8 on the ballot to step in. The defense team called only two witnesses, claiming that Supreme Court precedent was on their side, arguing that redefining marriage would weaken it and that traditional marriage, they said, was best for raising children. We know now how that worked out for them. Judge Walker saying that evidence from the trial showed that same-sex parents and opposite-sex parents are of equal quality and that Proposition 8 does not make it more likely that opposite-sex couples will marry and raise children. Judge Walker also saying that Prop 8 violates the U.S. constitutional guarantee of equal protection under the law by treating same-sex couples differently without a sufficient legal reason. The time has passed, he said, when the genders were seen as having distinct roles in society and in marriage. Gender no longer forms an essential part of marriage. Marriage under law is a union of equals. Governor Schwarzenegger, the non-defending original defendant, saying tonight in a statement, this decision affirms the full legal protections and safeguards I believe everyone deserves, adding that today's decision is by no means California's first milestone, nor our last, on America's road to equality and freedom for all people. Attorney General Brown of California saying, Judge Walker came to the same conclusion I did when I declined to defend it. Proposition 8 violates the equal protection guarantee of the 14th Amendment of the United States Constitution. A minor victory for the defense team, however, primarily because its lawyers knew they were likely to lose. In advance of the decision, they filed papers asking the judge for an immediate stay if they lost. Judge Vaughn Walker agreeing to put his ruling on hold, at least for a few days, to consider arguments on whether Proposition 8 will continue to be enforced during the appeals process or ended immediately, a move that would allow county clerks to begin issuing marriage licenses to same-sex couples nearly immediately. First, let's discuss the ruling, the case, where it's likely headed in court, with Lisa Blatt, Supreme Court appellate attorney who has argued before the nation's highest court 28 times and winning all but once. Thanks for your time tonight.
Thanks, Keith.
Firstly, Prop 8 overturned but not yet. For those intending to rent tuxes, how does this play out in the immediate future?
Well, I think it's clearly a resounding victory for the gay rights movement, and it is a cause for celebration. But I do think the district court will enter a stay. And if the district court doesn't do it, the Ninth Circuit would. And I think both courts are likely to want to enter a stay to keep that issue away from the Supreme Court for now.
And therefore, what happens relative to the Supreme Court? What happens to the prospects of same-sex marriages being resumed in California?
Well, I think it will go straight to the Ninth Circuit, and it will probably, most likelihood, be affirmed by the Ninth Circuit, and then the proponents of Proposition 8 will most certainly try to get the Supreme Court to overturn that. And if the Supreme Court declines review, then there'll be same-sex marriage in California. But I think that there's a very significant chance the Supreme Court will take the case if the Ninth Circuit affirms.
Will there be a stay that will carry through the circuit court's handling of this, as you suggest it's affirming of this decision?
I think so, because the proponents of Proposition 8 are not going to just give up. They will continue to fight this all the way to the Supreme Court. And I don't think the trial court or the Ninth Circuit wants the Supreme Court to reach the issue of a stay. So I think the lower courts will just enter the stay to keep the status quo. But it will proceed, I would think, expeditiously in the Ninth Circuit. The Ninth Circuit will not sit on this. They will act quickly on it.
At the Aspen Ideas Festival, Mr. Boies described how he and Mr. Olson had managed to sway all the defense witnesses to the extent that the defense witnesses, that were all opponents of gay marriage, largely dropped off the witness list or actually wound up saying that gay marriage should be recognized once they were deposed or they're cross-examined by Boies or by Olson. What does that tell us about the merits of the case, and what does that tell us about when we presume it gets to the court, what the case is going to look like to the Supreme Court, and how the Supreme Court could possibly what the court would hear?
Well, I think it says a lot about the evidentiary support. The proponents of Proposition 8 did a terrible job putting on evidence. They promised a parade of witnesses, and then they all dropped out, as you said, and they came up with 2. And the district court found those 2 witnesses both unqualified and not credible. And I think that's not the real problem. The real problem that the proponents have, and this is what the case is really about, is does the state or do the voters of California have the right to declare that same-sex marriage is morally inferior to to marriage between a man and a woman? And that's what's going to be the issue before the Supreme Court, whether the state has any legitimate interest in telling homosexuals whether they have a right to marry or not. And it will not be based on evidentiary support about what's best for the child or what's best for society, because I don't think the proponents put forth any evidence on that. In fact, all the evidence went against the state on this. The trial court specifically found it had 80 findings of fact, and one of them was that children raised by same-sex couples are as healthy and as successful and well-adjusted as those raised by heterosexual couples. And there's finding after finding like that. So the proponents aren't going to have any evidence to go to the Supreme Court with.
So what they would then do, I would presume, would be to change approach entirely and make this entirely about the right of ballot props to be initiated?
Well, it'll be the right about whether the Constitution can regulate morality. And I think what the district court was saying was that just declaring moral superiority is not enough when it discriminates unless the state has a legitimate interest. And this clearly on its face discriminates against sexual orientation. And the only question before the Supreme Court will be, is that rational? Does either a state government or the voters of a state have the right under the Constitution to do that, to make that kind of moral judgment?
Supreme Court Appellate Attorney Lisa Blatt, thank you for your time and your insight tonight. It was truly insightful. We appreciate it.
Thank you.
For more on the political fallout of today's ruling, let's bring in Joe Solmonese, president of the Human Rights Campaign. Joe, good evening.
Good evening, Keith. How are you?
What does Judge Walker's decision mean to you and your organization?
Well, it's a sweeping decision. It's an incredibly important decision, and it speaks to so many of the ideals that we've been putting forth for years now. I mean, he spoke to the dignity of same-sex couples. He spoke to the fact that sexual orientation is an immutable human characteristic. He spoke, as Lisa mentioned, to the strength and the commitment that we have to raising our children. But most important is something I think that we've all known all along. He spoke to the fact that the denial of marriage equality to same-sex couples is not just unconstitutional, it is harmful to same-sex couples and their families, and that to convey or to allow same-sex couples to enter into marriage does absolutely nothing, not one thing, to impact anybody else's lives, particularly heterosexual people who are married.
Did Judge Walker reaffirm your assertion and the assertion of the HRC all this time that this is a civil rights issue?
Absolutely, absolutely. I mean, the strength and the power of his conclusions today was historic, and certainly, as Lisa mentioned, sets an incredibly strong precedent moving forward. But it is a fundamental civil rights issue that we have been fighting for some time now. And again, this notion that our opposition has put forward that allowing same-sex couples to celebrate and to enjoy full marriage equality and to therefore be in a position to make decisions about our health care and our welfare of our loved ones and our children, particularly at times when we are at our most vulnerable, is something that seems so fundamentally obvious to so many of us, but obviously an idea that we need to continue to push forward as this case continues to make its way towards the Supreme Court.
What I drew, Joe, from Lisa Blatt's commentary in our conversation earlier was that this is essentially being fast-tracked into the appellate court and then almost presumably immediately to the Supreme Court, as immediately as the Supreme Court takes anything. What are your what do you infer from the decision today about how this will ultimately end up with the Supreme Court?
Well, I think the strength of the decision and the sweeping scope of the decision has a lot to do with it, and so I'm cautiously optimistic, but I continue to maintain that there are a number of roads forward towards marriage equality in this country. There is, of course, the route through the courts, as we're talking about today, but there continue to be legislative opportunities, and I think as an organization and as a movement, we need to continue to be steadfast to make sure that we in no way step back from that, whether it's the opportunity to elect a pro-marriage legislature in New York or a pro-marriage governor in Minnesota, or just the work of really changing the hearts and minds of the American people to continue to move them in the direction of supporting marriage equality.
Not to be grotesque about this, but also aren't the actuarial tables in your favor? Is there not, with every passing generation and each demographic group that we look at, the younger you get, the less sense any of this makes to 25-year-olds, 20-year-olds, 15-year-olds who are going, what is the big deal here?
Yeah, unquestionably. I think the statistic is if you're under 50, you support marriage equality by 54%. If you're over 50, you support it by 34%. So, yeah, time is on our side here, and we continue to move in that direction. But at every level, generationally, I think slowly but surely we are moving the meter of public support in the direction of supporting some measure of marriage, some measure of same-sex recognition, and ultimately marriage equality.
Joe Solmonese, president of the Human Rights Campaign. Such as they are, my congratulations to you and my thanks for your time tonight.
Thanks, Keith.